we're living through this incredibly urgent technological moment. It's just dominated by AI, this massive data accumulation, pervasive surveillance.
Absolutely. And you can feel it. We see that the very structures of our society, our people, our democracy, they're paying a really hefty price.
And that price, it's a direct consequence of let's say, a flawed vision of U.S. privacy law that took root over 50 years ago.
Exactly. And to govern AI justly now, we really have to understand where that original regulatory failure came from.
So that's where this deep dive is going to take us.
Yeah, we're looking at this powerful analysis of a historical crossroads right in the early 1970s. This was the real dawn of modern computerization.
And the goal is to understand how a really powerful substantive privacy movement just lost its way.
It's an essential journey because the stakes then were, they were the same as the stakes now. Who controls the technology and who benefits?
Okay, so let's unpack this history. Our mission today is to trace how these truly robust privacy protections laws that fundamentally limited what data could even be collected.
The really strong stuff.
Right, how they were undermined and systematically transformed into these, weak procedural frameworks.
What we now know is the totally ineffective notice and choice regime.
Yeah, we're going to follow this trajectory of failure, which was ultimately defined by the influence of three key factors we're calling the 3 Ws.
And, understanding this history is really the shortcut to understanding why AI regulation is so difficult today.
Before we jump into 1972, we do want to briefly thank our sponsor.
Navigating this history of compliance and regulatory failure, it just underscores how important it is to stay informed.
Especially in this chaotic landscape. So thank you to our sponsor. You can find reliable resources and compliance insights at www.compliancehub.wiki.
All right, let's start that historical detour. If the 70s were this crucial moment, where was the high point for privacy law before it all started to decline?
That's a great question. The high water mark, according to the sources, was 1972.
Specifically with the passage of the California constitutional right to privacy.
And it's so noteworthy because it was the last truly comprehensive privacy law enacted in the U.S. It set a standard that, honestly, has yet to be matched at the federal level.
So what made it so much stronger than everything that came after it? What did it actually protect?
Well, it was comprehensive in two really crucial ways. First, it protected both autonomy privacy, so freedom from physical intrusion, surveillance, and informational privacy.
Which is the right to control your own personal data.
Exactly. And second, and this is critical, it protected you against intrusions by both government and business.
Okay, so it treated the public and private sectors as, equally dangerous to individual rights.
That's right. And that scope is just fundamentally different. The core feature was that it was an allocation of power to the people.
How so?
It declared that privacy was a fundamental and compelling interest, and that it should be abridged only when there is compelling public need.
Wow. So the burden of proof was squarely on the invader government, corporation, whoever, to prove an overwhelming need before they could touch your privacy.
Yes. The starting line was, your right to privacy is nearly absolute. It's a completely different footing than today, where we just assume data collection is allowed until proven otherwise.
It really is, and this push for substantive limits, it was rooted in these bold ideas from the late 60s and early 70s.
This was all happening before the weak procedural frameworks even took over.
Right. So what were the experts arguing for back then when the computer age was just, taking shape?
They were arguing for controls on input.
Yeah.
They recognized that once information was collected, it was almost impossible to control.
So the law needed to be substantive. It needed to prohibit what information could even be collected in the first place.
Exactly. Experts were saying for certain sensitive data, we just shouldn't collect it, period. The philosophy was all about prevention.
Not just mitigation after the fact.
And the public was behind this. By 1967, people were expressing grave fears over a proposed national data center.
Seeing it as this vast, unchecked government surveillance machine.
Yeah. By 1971, one observer noted that people felt imprisoned in a web of imperishable data.
And this wasn't just an academic concern. The sources are clear that this desire for robust privacy was championed by intersectional social movements.
It was integral to the fight for justice. Activists knew that technology was a tool of oppression.
They knew they were being surveilled, often with new tech like electronic wiretapping, something later confirmed, of course, by the exposure of the FBI's COINTELPRO program.
And the most compelling example of this has to be in the Black Panther Party's platform.
Precisely. Their 10-point plan explicitly included a demand for people's community control of modern technology.
They saw a technological control not as some side issue, but as integral to their demands for land, bread, and justice.
Absolutely. So if you have that level of power and political energy focused on substantive privacy rights, how did the U.S. manage to lose that path so spectacularly?
That is the critical juncture. By the mid-70s, the burden just shifted dramatically.
So instead of the invader needing to prove a compelling interest to collect data,
The focus morphed into these complex, often nebulous due process safeguards, which put the heavy burden of enforcement squarely on the individual.
and this sideways shift was powered by the convergence of our three key factors, the three Ws.
Okay, let's start with W1, the war on drugs. How did a domestic crime policy end up changing the whole legal approach to data privacy?
Well, the war on drugs was, a political maneuver. Conservative Southern politicians reframed their backlash against the civil rights movement as a non-racial law and order agenda.
And they leveraged public fear of crime, especially after Dr. King's assassination, to push for policies that dramatically increase policing and surveillance.
So it wasn't just a distraction, it was a mechanism to justify expanding the state's surveillance capacity.
That's right. It led directly to laws like the 1968 Safe Streets Act, which just poured money into local police departments, fueling more data collection.
And this expansion diverted activist energy, but it also normalized the idea that government had a right to collect vast amounts of information on its citizens.
Right. And that set a really poor precedent for the private sector later on.
And the courts followed suit. Federally, we saw the erosion of Fourth Amendment rights in cases like Terry v. Ohio.
The stop and frisk case.
Exactly. And the consequences were long-lasting. Even in California, the Supreme Court there became more conservative, leading to a 1994 case, Hill v. NCAA.
And that's the case that neutered the powerful 1972 constitutional right we were just talking about.
Precisely. The court basically lowered the bar for what counted as a valid justification for infringing on privacy. It made it incredibly difficult for people to actually enforce their own fundamental rights.
Yeah, so W1, the war on drugs, erodes the political and judicial foundation. It makes surveillance acceptable. But W2 provided the intellectual blueprint for a weaker system.
One that businesses could live with. Let's talk about Alan Weston.
He's often called the father of modern privacy law.
He is, but our sources indicate his influence was critical in sealing this weak future for privacy regulation. He was instrumental in shifting attention away from substantive limits.
And toward these weaker procedural guardrails.
Exactly. His key work, Databanks in a Free Society, came out in 1972, and it basically accepted widespread information collection as inevitable. Necessary, even.
Contending there was a societal need for data?
Right. So instead of saying, you can't collect this, he offered procedural safeguards. Things like transparency, giving you access to your records.
So he essentially traded a robust shield for a porous safety net. He said, okay, keeps the data, but you have to be nice about it.
That's a great way to put it. And critics at the time, they warned that relying on these procedures would actually legitimize intrusive practices. It obscured the deep power imbalances.
It sounds like a recipe for compliance theater.
In many ways, yes. Which brings us to W3, Willis Ware and the federal committees. These were the groups that formalized Weston's approach and turned it into the weak law.
Ware was a crucial figure, chairing the HU committee and then vice-chairing the Privacy Protection Study Commission, or PPSC.
And that HEW committee from 72 to 73 developed the Fair Information Practice Principles, FIPS.
FIPS sounds good on the surface. But what did it actually do?
It was a safeguards approach. It focused on transparency, fairness, individual access. But critically, it generally did not limit what information could be collected.
And the plan was for it to apply to both government and business.
That was the plan. But the resulting law, the Privacy Act of 1974, was a catastrophic failure on that front.
Why?
It was a compromise enacted in the shadow of Watergate. It was supposed to restore trust, but it only applied to federal government agencies.
It completely excluded the private sector.
Completely. And it only established weak procedural safeguards. It just punted on regulating business entirely.
So weak government regulation and zero private sector regulation.
And that's where the second committee, the PPSC, came in. It issued its final report in 1977, and its recommendations were heavily industry-oriented. They favored notice and self-regulation.
And this is where the failure was truly cemented, wasn't it? Prioritizing one value above all others.
Exactly. The PPSC report made the defining error of modern privacy law. It elevated the costs to business as the most compelling competing interest against individual privacy.
That one accommodation, placing corporate economics above fundamental human rights, is the legacy we are wrestling with today.
It's just staggering. A report from 1977 created the corporate playbook we still see. Fast forward 50 years, and that same logic is driving the regulatory vacuum around AI.
The costs are just incredibly high now. The source material uses this powerful analogy for it.
It does. It says that relying on process safeguards since the 1970s has been like bringing a pocket knife to a fight when the other side, big tech, has a fully loaded tank.
That perfectly captures the feeling of powerlessness. I mean, anyone who clicked through dozens of cookie banners knows that feeling.
Yeah, the notice and choice regime is now, universally seen as beyond broken, a complete fiction.
It's designed to invite unwitting and coerced consent. Studies show people care about privacy, but they feel powerless to stop it.
Because the entire compliance burden is on them.
And now we're seeing big tech recycling the exact same playbook from the 70s to block meaningful regulation for AI. They're touting trustworthy AI, which is just code for weak transparency, and that same failed notice and choice framework.
We've seen the show before. They use the whole tech equals progress narrative to justify externalizing the costs of their operations onto society and individuals.
And while businesses do need tools to manage this mess, and again, reliable resources like those at our sponsor, www.compliancehub.wiki, are essential for navigating this environment.
Right.
The legal landscape forces individuals to shoulder an impossible compliance burden themselves.
So the necessary course correction, drawing on the lessons of the 70s, is to go back to substantive laws. We need robust rules of the road for AI.
Moving beyond just process safeguards.
Yes. We need multi-level governance, local, state, federal, that explicitly centers people over profit. And we have to put some uses entirely off the table.
Can you give an example of something that should be off the table?
AI for face surveillance in high-stakes decisions. Criminal justice, immigration, policing. These technologies are just too invasive, too prone to bias. Substantive laws have to prohibit them outright.
Which leads us to the path forward. Building social movement power. The sources argue a key challenge is the woefully weak narrative discipline of the public interest community. Why is narrative so critical?
Narrative discipline is about consistently framing the debate on your own terms. Industry has deployed 5 pervasive, consistent narratives for 50 years. If we don't counter them effectively, they just win by default.
Okay, let's break down those 5 narratives. What's number 1?
The first is, good for technology, good for the world. The myth that what's good for a tech company's bottom line is inherently good for humanity. It justifies all the externalized costs.
Think of Facebook's claims about connecting the world versus their own internal memos about the ugly truth of the damage it caused.
Exactly. The second, more aggressive one is, resistors are Luddites.
Right. Anyone who challenges the premise or calls for limits is accused of being anti-innovation, anti-progress.
And that narrative has been used to shut down debate since at least 1971.
The third one aims to just paralyze people.
Correct. Technology is inevitable and people should feel powerless. That's when you hear, the train has left the station. The goal is submission, not democratic participation.
And the fourth is designed to undermine intellectual engagement entirely.
That's technology issues are too complicated. This idea that regular people or politicians can't possibly understand it enough to regulate it, we hear it as, you'll break the internet.
And now it's manifesting as AI washing.
Exactly. And finally, if all else fails, they just deny responsibility.
Number 5. Technology is neutral, and companies are not responsible for its use. The flip side of the first one. They claim it's just a tool.
We saw that with Jeff Bezos dismissing concerns about their face surveillance tech, saying society will just develop an immune response.
But the sources also highlight that when the counter-narrative is strong, real change happens. The campaign against face surveillance is the perfect example.
It's the model of success. That campaign used integrated advocacy legislation, corporate pressure, organizing, litigation to spur clear, tangible change.
And it worked.
It did. It resulted in dozens of local bans, state laws, and even moratoriums on sales from Amazon, IBM, and Microsoft.
So the key takeaway is that advocates have to develop a powerful, consistent social justice narrative, one that replaces that feeling of powerlessness with intersectional power.
It has to transform resignation into indignation. That's how we learn from the failures of the 1970s and actually build enduring structures for change.
Absolutely. The failure of the 1970s wasn't the lack of good ideas. It was the failure to sustain a cohesive power base and a narrative strong enough to win. To avoid replicating that failure with AI, we have to focus on building that power today.
A huge thank you for exploring this deep dive with us.
And one last reminder that as this regulatory environment changes so fast, reliable resources for understanding compliance standards like those at www.compliancehub.wiki are just essential for the fight.
Before we go, here is a final provocative thought for you to take away. If the PPSC report in 1977 elevated cost to business as the most compelling interest against privacy, what competing interest, is it efficiency, is it security, something else, will define the future of AI regulation? And what will it cost all of us if that interest isn't centered on fundamental human rights?
Think about that. Go use this knowledge. We'll see you next time on The Deep Dive.